Welcome. We are visiting the provisions of the Indian Evidence Act regarding relevancy. As we have observed in the initial sections 5 to 9, the concept of relevancy is the basic concept. It is a foundational concept because evidence can be led only with respect to the facts in issue and the relevant facts. Now, this concept being a foundational concept, being the basic concept, and having a legal sanction behind it, and it being of a practical importance as one is to prove or disprove a particular ingredient of a particular offense or a particular issue in a suit. Therefore, we should be well acquainted with, we have to observe it fully, the concept of relevancy effects and the permissibility in terms of relevancy under the Indian Evidence Act. Today, we are focusing upon Section 10 of the Evidence Act. This section is important as it is with respect to the offense of conspiracy. And the offense of conspiracy, Section 120A as definition and 120B as punishment provision in the Indian Penal Code. As such, it is an offense which has been introduced subsequent to the original, the frame of the offenses. Now, offense of conspiracy is a class in itself, and the offense as it has been defined is simple an agreement to do something illegal or to do something legal, but by illegal means. And if that agreement to do illegal thing, if otherwise is an offense in itself, then the agreement to commit that agreement becomes a distinct offense. So there is one offense, say, of a murder, and the conspiracy to commit murder is an independent offense. So murder and conspiracy to commit murder are two distinct offenses. This distinctiveness of the conspiracy as such is being taken up here in Section 10 regarding the relevancy of the facts. Let us read this section thoroughly. When there is a reasonable ground to believe, see, only a reasonable ground to believe, and that to believe. So it is belief, and it is a reasonable ground for the belief that two or more persons have conspired together to commit an offense. So, as far as the relevancy aspect is concerned, it is only the reasonableness of for the belief. So, if there is a belief and there is a reasonable ground for the belief that persons have conspired together to commit an offense or an actionable wrong, anything said, done, or written by any one of such persons. So, see, this beginning is with the reasonable ground for a belief, and that two or more persons have conspired together. What for? An offense or an actionable wrong? See, the actionable wrong is a tort. Actionable wrong is in between the civil cause and the perfect criminal cause. So, to maintain a continuity and to see there is no escape for anybody, therefore the word used is actionable wrong. So, there should be reasonable ground for the belief that two or more persons have conspired together to commit an offense or an actionable wrong. In such a situation, anything said, done, or written by any one of such persons So see, what is the generic basic feature of this section? That if there are more than one persons, there are two or more persons, and they have conspired together, then in that situation, the act done, anything said or written by one of the conspirators, that becomes irrelevant. And this relevance would imply that it will have an effect upon the other person, as if other person has also done it like this. Therefore, Section 10 is a very delicate fabric of reaching the conspiracy. Conspiracies are usually hatched in secrecy. Something conspired, something agreed, a mental state reached at in secrecy. So, effort of the law is to reach that agreement, meeting of minds of the individuals in secrecy. So everything is being done in secrecy, number one. And that secrecy situation is further goes deeper when it is simply a mental state. A and B are mentally agreeing. So that is a mental state of unison of the two persons. So A and B are doing something in conspiracy. And what they are doing is they are agreeing. So it is going to be interaction of mind A with mind B. And then everything is in secrecy. So see how deeper is the layers of the crime from which the law is to reach at the conclusions. Therefore, it is in this background we have to appreciate that this section provides that if one of the conspirators has done something, acted in a way, or has written something, then that thing, that action done, or that written document, writing of one of them becomes relevant. And this relevancy would mean permissibility for an evidence, and permissible for evidence would mean it will become the basis to prove the offense of a conspiracy, and that will be against all the conspirators. So the act done or document written by one of the conspirators is relevant evidence under this section. So the permissibility, and once permitted and admitted in evidence, then it will become an evidence against all. So this section is a very important section from that point of view. Now let us read it. And there is reasonable ground to believe that two or more persons have conspired together to commit an offense or an actionable wrong, anything said, done, or written by any one of such persons in reference to their common intention. So, act done or something written by the conspirator should be in reference to, in connection with, in furtherance of the common intention. So the restriction or the touchstone by which the act done or some document written by one of the conspirators is to be tested by the touchstone of whether or not it is after the conspiracy stands agreed, hatched, and act done is in reference to the common intention. Therefore, while relevancy is to be defined, is to be appreciated with respect to a particular act done by a particular conspirator, or some document, some writing of one of the conspirators, then the two tests will be: first will be whether this act done or document written is subsequent to the conspiracy having been hatched. And second test is that that act done or document written is in reference to the common intention. These two conditions are to be satisfied to make the act done by an individual or document written by an individual to be relevant under Section 10. So it is said, is a relevant fact as against each of the persons believed to be so conspiring, as well as for the purpose of proving the evidence of conspiracy, as for the purpose of showing that any such person was a party to it. So, see, this piece of evidence which becomes relevant is to be utilized for what purposes? Number one, to show that which person is party to the conspiracy. This piece of evidence is also to be availed for proving the conspiracy itself. So to prove the conspiracy itself would mean to prove the common intention as well. So see, when it is believed that a particular person is a conspirator, if there is a reasonable ground to believe that particular person is a conspirator, and after the hatching of the conspiracy, the referred act or writing is in furtherance of the common intention. But this is one aspect. But to prove whether or not particular person is a party to conspiracy, one aspect. Whether or not conspiracy was hatched, what was the common intention. So these three ingredients, which in fact are the prior ingredients for the offense of for conspiracy itself. And then here what is being said, when there is a reasonable ground to believe. So everything is being taken up from the stage of a reasonable ground to believe. And then on that reasonable ground of belief, the acts done or the conduct and writing by any individual is being made relevant for wide range of situations. Number one, whether or not a particular person is a party to the conspiracy. Number two, what precisely has been the conspiracy and what has been the common intention of the individuals. And then further, that act or conduct is subsequent to the time of hatching of the conspiracy, and further that act or writing is in reference to the common intention of the parties. So this section is a lawful answer for the conspiracies which are hatched in secrecy, when conspiracies are the mental state agreements. So some minds interacting in secrecy are to be read, are to be reached at. Conspiracies are hatched in secrecy. Conspiracies are the agreements of the mental states. So the challenge before the law is to reach at a 2 or 3 minds agreeing in secrecy. So how big is the challenge? And appropriately, the law has approached it from the reasonable ground, and that too for a belief. So reasonable ground for belief that conspiracy has been hatched, and then the acts done and writings are being made relevant. Therefore, we as students of law, we as analysts, and we as advocates, when are confronted with this situation, this charge of a conspiracy, then this section is going to be the most relevant provisions for leading an evidence, objecting an evidence, proving an offense, disproving an offense, reaching at that offense stands proved beyond all reasonable doubts or not. Because we start with a reasonable ground. We are starting with a reasonable ground for, and that too for a belief. This is the starting point. But the end reach is to be beyond all reasonable doubts. There are 3 situations now. One is that conspiracy is being hatched in secrecy. That conspiracy is going to be of a mental state. Then this mental state reached that in conspiracy will have its manifestations, its physical imprints. The physical imprints of such mental states, of such secrecies, are to be approached. The ultimate reach is to be of a proof of beyond all reasonable doubts. So the ultimate standard is going to be of a proof beyond all reasonable doubts. So something has been done at a mental state in secrecy. The standard of proof for punishment, for holding guilty, is going to be beyond all reasonable doubts. Now, between these 2 situations, the trial stage, the evidence leading stage, the attempt to prove or disprove the same, is being approached by the law, by the Evidence Act, under Section 10, that we may start from the stage of a belief. We may start from the ground of a belief, but on a reasonable ground. And then the belief on reasonable ground is being ended with respect to the acts done or the documents written by an individual. Now, this act done or writing is to be subsequent to the date of the conspiracy. This act done or document is to be relevant to the common intention of the conspiracy. And then this relevancy for such act and document, once made relevant, once permitted, once admissibility to it is there, then it can be utilized firstly against all the conspirators. Secondly, it can be specifically utilized to prove the existence of a conspiracy, to prove the common intention, and also to prove that the conspiracy which was hatched has been acted upon or not. So whole range of gambit, whole range of this trial is being approached by Section 10. So Section 10 on the one hand, the ultimate test of proof beyond all reasonable grounds on the other end, and the conspiracy is being hatched in secrecy. So something done in a secrecy is to be proved beyond all reasonable doubts, and for it, the start can be from a belief on a reasonable ground, and the same is to be in terms of act done or something written by any one of them, and that to be utilized against everybody. As such, now the later part of this section says reasonable ground exists for believing that A joined in a conspiracy to wage war against, say, government of India. Now, this is a reasonable illustration given here is under this section. Say the reasonable ground is that A has joined a conspiracy to wage war against the government of India. It's a reasonable ground. Now, the fact that B procured arms in Europe for the purpose of conspiracy, C collected money in Calcutta for a like object, D persuaded persons to join the conspiracy in Bombay, E established writings advocating the object in view at Agra, and F transmitted from Delhi to G at Kabul the money which C had received collected at Calcutta, and the contents of the letter written by H giving an account of the conspiracy are each relevant both to prove the existence of the conspiracy and to prove A's complicity in it, although he may have been ignorant of all of them, and although the persons by whom they were done were strangers to him, and although they may have taken place before he joined the conspiracy or after he left it. See, as previously Subhash has pointed out, that illustrations are providing us very clear mirror to have appreciation of the features of the substantive legislative provisions, and here Section 10, an illustration behind it, beneath it, is well illustrated. Reread it, punctuate it well, and then reach at the real implications of this provision. Thank you very much.
Thank you, sir. With the illustration, it is becoming quite clear, sir.
Yes, but as you see, without illustration, it was not possible to have that appreciation. But we shall have a mind of such state that we can draw inferences from the text itself.
Yes, sir.
That is the requirement. Illustration here is helpful. At some other places, there may not be such illustrations, or these illustrations may prejudice as well, because there may be many other shades of reality situations which may not be covered by a particular illustrations, and our mind may sometime get fixed as if that section applies only that much. Therefore, text is to be read independently, and it is only thereafter the illustrations shall be utilized.
Yes, sir.
Thank you.
Thank you.